Mr. Seward, going back to Thunder Basin, I told Mr. Clement that I thought his worst factor was meaningful review. I think that the other two factors are pretty darn bad for you. On expertise, the Court and Free Enterprise Fund, whatever distinctions there might be as between Free Enterprise Fund and this case, the Court and Free Enterprise Fund just says you lose on expertise. Then on collateral, I think just the ordinary understanding of what we mean when we use that term is it unrelated to the essence or the subject matter of the dispute, and a claim that goes to the legitimacy of the agency structure as a whole is completely unrelated to the subject matter of this suit. So why aren't those two pretty easy wins for Mr. Clement?
I think even as to the expertise factor, the SEC may have lacked expertise regarding the way in which the removal protections for the PCAOB officers, but it certainly has expertise in the way SEC adjudications are conducted. But the second thing I would say is, if this were a challenge, for instance, to a rule of evidence that bound the ALJ, and it was being attacked on the ground that it violated due process because it didn't allow the respondent in the proceeding a sufficient opportunity to rebut the agency's charges, we would surely say that challenge has to go through the administrative scheme. It may, whether the due process challenge succeeds, may be unrelated to the merits of any particular allegation that a regulated party has violated the FTC Act, but it is still not collateral to the review provisions because it goes to the way in which the administrative adjudication will be conducted. And here we have basically the same thing, that the challenge to the removal protections for the FTC commissioners is a little bit different because the FTC does a lot of other things. If the commission issued a rule, then the rule could be challenged on the ground that the commissioners were unlawfully protected from removal. That kind of challenge is not inherently linked to an
if I just sort of cut to the core of your argument, you seem to be saying something like it's not collateral if it arose from an enforcement proceeding, but almost everything is going to arise from an enforcement proceeding. That you're basically making the collateral inquiry do no work at all.
I think there's a difference between asking, did it arise from the enforcement proceeding, and was it directed at the enforcement proceeding? For instance, the statute that governs the SEC, the Exchange Act, authorizes the SEC to issue temporary cease and desist orders that constrain the regulated party's conduct while the adjudication is ongoing. And that may be, and the Exchange Act specifically provides for district court review of those orders because they require the party to do more than participate in the proceedings themselves. They constrain the party's freedom of movement outside the proceedings. And those could be viewed as collateral because even though they are contingent on the pendency of an adjudication, they are still not part of the process by which the adjudication is resolved. They affect private conduct outside the scope of the proceedings themselves. I will say one other thing about the court's collateral review doctrine, collateral order doctrine, that both in the agency, I'm sorry, Mr.
You can finish your thought.
Both in the agency review context and in the collateral order context, really the only exception the court has recognized to the general principle that you can't get out of it simply by invoking the burdens of the proceedings. The only exception to that principle is claims of immunity. So the court has said adverse rulings on the double jeopardy clause, on state sovereign immunity, on qualified immunity, they can be appealed immediately, but other claims that would terminate the proceedings can't. What we have here is at the furthest extreme from a claim of immunity.